sat right in the middle of our space here. So it's this gentleman right here. For there we are. All right, so seeing a lot of regular faces here every week. Really appreciate everybody showing up, everybody adding to those conversations, adding to those connections. It's really what's a big part of what makes our 1 Million Cups community special. So thank you to all of you.
Awesome. And if you're as astute at counting as Tyler is, you've probably noticed there are still 2 more cups here in front of me, right? There were 4 and now there are 2. Another way of earning these cups is to come down and quickly share with us why you come to 1 Million Cups. If I have 2 folks that would like to do that, they are free for the taking. Well, they're not quite free. You have to say a little something. Anybody? Anybody feeling particularly brave this morning? Oh, yeah, Kayla, I knew I could count on you.
Always. Okay, anybody else been binging Game of Thrones stuff lately? Yeah, I know. Okay, so it's been really bad. But I like to surround myself with very smart people who know things that I don't know, and that's why I come to 1 Million Cups, so I can drink and you know things.
All right.
I come to learn great and new ideas and to network with others.
Thank you. Yay. Thank you. All right. And then there were none. Woohoo. All right. Well, thank you, everybody. Are we ready to rock this thing? Are we ready to learn about intellectual property? All right. Here we go. Now, unlike most MCs, I'm really hard to part with the microphone. So I'm just going to quickly cue up our panel, and then I promise I'm going to get some really smart, thank you for queuing that up, some really smart individuals up on the stage. And then we're going to hear a little bit about each one of them, and then we're going to grill them, and it's going to be awesome. Okay, here we go. So I just thought I'd start intellectual property, right, or IP for short. Just quickly, that is just the stuff in terms of definitions. That's the stuff that you create using your noggin. Okay, so it includes things like your inventions, your designs. It could be your literary or artistic work. So it could be a painting, it could be a play, it could be a book, it could be photography or videography, or it could also be your name, the symbol that you use as your mark for your name. You think of Coca-Cola with the swishy, swirly lettering, those kinds of things. All of that falls into intellectual property. Okay, so you got stuff, your noggin came up with it, how do you protect it? Intellectual property protection then falls into, there's some other buckets, but the 3 biggies are trademarks, okay, which is that symbol like Coca-Cola, TM, copyrights, which is that protection of works of art and that piece, and then finally patents. So who we've got today is we've got my dream team. When we were talking about this panel, I said, who would I really, 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 really want to see up on stage to talk about these topics? And this is my dream team. And I'm going to tell you about the team quickly, and then I'm going to bring them up individually and let them steal my microphone. First of all, we're going to have Marlo Anderson. I think most of you are familiar with Marlo. I'll do introductions in a little bit, but Marlo has some recent experience in the trademark space. So he's going to kind of be talking about that. He's got a very valuable brand, and he's going to talk about kind of protecting that brand and how that has impacted his business. Then we've got Jack Glasser, and you cannot open a publication or anything in this town without seeing Jack's images. Jack is going to really focus in on the area of copyright, because that has a big impact on his business. And then Evan Anderson, who, I hate to say this, my favorite panelist, sorry. Evan has a lot of experience in the area of patents, both in his own area as well as helping clients. And then finally, kind of, if you will, the anchor for this 4-person relay is John Sanstead, who is an attorney who has helped us through many situations and is going to keep the rest of us honest and correct everything that we've said the rest of the time. Right, John? Yeah. All right. So enough about that. Let's get to our panelists. So I'm going to have each one come up in turn, and they'll be slowly, the seats will fill, and when we hit full, we're going to open for Q&A. All right, so our first panelist is Marlo Anderson. And Marlo, know how to, okay, so I have to tell you a quick story. So Marlo is the keeper of national days. And the first national day I was ever familiar with was National Fig Newton Day. I learned about this, I was in Grand Forks, we were watching a hockey game, and I learned, hey, it's National Fig Newton Day. And I was so excited, because I'm a big fan. Remember the big Fig Newton and he danced? Anyway, I remember I said, oh my gosh, I have to have a Fig Newton on National Fig Newton Day. So we went to Super Pumper or something in Grand Forks, and I went running in and I found a big pack of Fig Newtons. And I remember telling the clerk at the front desk that it was National Fig Newton Day. And she was so excited. And as I was walking out, I heard her telling the person behind me, it's National Fig Newton Day. Did you know that? So anyway, Marlo, you've changed my life. I now, I've now moved on to things like National Beer Day and things that are really substantial and very important. So thank you, if you please join us. Oh, and
Yes, I do. Well, good morning, everybody, and happy National Cheese Ball Day to you. So, so National Day calendar has had some challenges in this space, and I'm a pretty open source type of person. I don't mind sharing, as most of you know, but I had a call probably shortly after we became a company, and the call was about, they were complaining about a product that they had purchased that they thought was ours, and it was a calendar. And they're like, why is this calendar so terrible? You have no national days on it and whatever. And I'm like, this doesn't even sound like us. What are you talking about? Well, as we got through the conversation, we began to understand that somebody had actually produced another calendar with our name on it. So it really got me thinking about maybe we need to start protecting ourselves. Not so much that I was really concerned about people maybe borrowing our property. It was more about that they were emulating who we are, and it hurts our reputation. So that's where we really started to, start thinking about this a little bit. And then you start thinking about the income that you could potentially lose, right? So for example, right now on Instagram, there's an account called National Day Calendar. It's not us. They have 50,000 followers on there. A follower to us probably equates to about $10 a year. So even if 1/10 of those people were to actually follow us, that would impact us about $50,000 a year. So they're siphoning off about $500,000 a year business from us. One account. So you can imagine what this is like when you go across all of the social media that's going on right now, and all of the places that are actually stealing our information and the things that we share. So those are the challenges that we have, and I welcome any questions that you have in this space. And by the way, what you're looking at right here, this was a long battle, by the way. This took us 4 years to get this, because we had a lot of challenges as we went through this. But as of the end of January, we actually hold the registered mark for Celebrate Every Day, as well as for National Day Calendar. So we were very, very happy to see these things show up in the mail. So we were pretty excited about that. But thanks, everybody.
thank you, Marlo. Appreciate that. Okay, so next I'll introduce Jack Glasser. Jack is a fantastic success story. I remember we first moved back to Bismarck in 2005, and Jack was just getting started, and it's been really fun to watch as he grows his business. So Jack, if you'd be willing to come on up and talk to us a little bit about how copyright has impacted you.
Well, as she said, I am Jack Glaser, the founder of Glaser Images. We're a photography and video company focused in weddings, commercial work, and portrait photography. Started the company in 2005 when I was 16 years old in high school, and have grown the company to an amazing team of 77 photographers, videographers, and business support staff, 23 of which are employees, and we do have 54 subcontractors doing business in North Dakota, South Dakota, Minnesota, and Colorado, as well as the surrounding states around those states. Copyright has affected us with our team, of course, in the form of license agreements, clients in the form of contracts establishing and reminding them of copyright, their copyright releases, copyright issues, those sorts of things, as well as the overall direction of our business practices and policies in the form of how clients use our photos and kind of the compensation structure as well. So certainly excited to hear and answer any questions that you guys have.
Awesome. Thank you. Thank you, Jack. That's a really important space. I think I might have violated some stuff, so we'll talk about that later. Okay. Next to the stage, I welcome Evan Anderson, who, as I said, my favorite presenter because I've known him for a really long time. But Evan's had a lot of experience kind of in that patent space. So
Good morning. Thank you. So in my business, Gizmonics, we do product development for clients as well as some of our own products. So obviously patents are top of mind in these cases. And so just wanted to talk, and it's a conversation I have with virtually every client, and it's always a difficult decision in terms of do you do it, what type of patent, when is it appropriate to spend that money versus spending the money in all of the other 10,000 places that need money at that point in a business. Just want to talk briefly about really 3 different kinds of patent applications that we see fairly regularly, except we don't see it right now at all. There it is. I thought maybe the bulb finally went. So the first is a provisional patent application. And maybe you've heard of this. This essentially gives the applicant a year of protection, or if you will, or it gives you the ability to say that you're patent pending for 1 year. It sets what's called a priority date, so that starting as of that date, you've got that protection. Now, you've only got 1 year then to file a utility patent, which is, I just call it a full patent, I guess. But it's kind of an important year because you can use that year to further refine your product, your idea. Maybe you make some changes that you think, oh my gosh, I'm glad I didn't patent that because now I've made this change and it's different. The other thing that I like about it is if you find somebody that might want to license your idea from you before you've spent all the money on a utility patent, you can basically make that part of your licensing deal with them. They can take that, they can spend the money. They might have attorneys that are on staff that can do that. So it's a really good tool. The filing fee is like $70 for a small entity, so it's pretty approachable to file that. So that's one that I use quite a bit. The design patent is next, and the design patent really just protects the design of like the visual. What does it look like? There are no words basically in a design patent. It's an image or a set of images that really cover what it looks like. So if you've got a design that's somewhat artistic, and John can probably speak to this too. He's probably seen some examples, but it visually covers what it looks like. So if somebody copies that look to where it creates some confusion or potentially creates confusion, you would then have the right to protect that or to defend it basically. And then utility patent, that's the patent that we're all most familiar with, the big long one with all of the claims, where you claim all of the different things within your device that you're protecting or that you're claiming. And then when you file that, then the patent office gets back to you 2 years later and tells you all the things they don't want to accept about it, and it starts this cycle of expense. So I guess also personal experience, if some of you saw me on stage, I think that was just late last year, my product is on the left, the Pumpkin Gutter, and Pumpkin Master's version is on the right. I've got a pending design patent because the patent office didn't grant us a utility because they said it was too much like something that didn't make any sense, but it's their prerogative. But anyway, so I've had some recent experience with actually having intellectual property ripped from my hands without me wanting them to. Also, in the same Halloween space, we have a distributor that has a fully utility patented product that was stolen the same season by the same company. And as I think we'll probably be talking in our discussions more about, having a patent doesn't just automatically, it's like if somebody infringes, lightning strikes and they blow up. It just gives you the right to defend that patent. And I hear different numbers, but it's hundreds of thousands of dollars potentially to do that, depending on where that battle takes you. So I often recommend to clients, if that happens, you just walk away. It's just not worth it. So I look forward to your questions.
thank you, Evan. And anchoring my dream team is none other than John Sanstead. And worked with John for a long time, I think since we very first moved back to Bismarck, and he's been very helpful in questions regarding all of the above. So John, if you join us, please.
Thank you all. It's an honor to be here. Intellectual property is really important to any business. But what I can't stress enough today is intellectual property doesn't make you money. It's your marketing efforts, it's your selling efforts, it's getting out there and promoting your product. What intellectual property does is once you've gotten out there and taken some part of the market, what the intellectual property does, and what we're talking about today, tries to help and protect that portion of the market that you've gotten so that someone can't come and steal it from you, whether it be a trademark, whether it be images, whether it be a product. So really what we're talking about today is, you've got an idea, you're going out there and marketing it. How do you protect it then once you've got a market share from someone coming and stealing it? And I can tell you it happens every day. Someone sees a great idea and doesn't want to work for it, figures they can capitalize on it. So these guys are the brains, they're the creative ones. I'm happy to help them in any way I can, but these are the ones that guys have been through it, and I'm sure they'd be happy to answer any questions.
Okay, so I'm going to follow John across the stage and make him nervous. So here's how it goes. We are now going to open it up to Q&A. Again, remember, if you're feeling shy, hashtag 1MCND, and Lakin will ask it for you. Otherwise, wave down Tyler here with the microphone, and he would be happy to hand that to you, and you can pose your questions. And we've got everybody's name up here, though, I'm sure you remember, and I guess I will just kick things off. I think, John, I'm going to follow up on your opening comments. Sorry, you're in the hot seat. So you were talking about, so once you've got that market share, this is how you kind of protect that. Where in the process would you encourage someone to protect their idea? Like, should Marlo have started on day one when he didn't know if National Day Calendar was going to be anything? Or was it later down the road when he started to get that market share?
Let me just focus on trademarks for just a minute. There's really two reasons to delve into trademarks when you're first starting a business. One is you're going to put some money into your brand, whether it's a National Day Calendar or whether it's a logo, whether it's stationery, whatever you want, whatever it is, you're going to put some money into it. You want to, if you have a really creative name, you want to protect it. The other thing you need to be sure of is that you're not stealing someone else's name. So the last thing you want to do is put all kinds of money into marketing only to have a year later someone send you a cease and desist letter saying, you got to quit using that name. We have the trademark for that. So you got to be very careful. It's not only protecting your name, it's making sure you don't infringe on someone else's name. As far as when do you start that process, oftentimes I will get clients in who want to, before they even let the name out, because they think it's so great, they want to protect it today. And I can understand that. I mean, their whole company is going to be focused on this one particular name. And if that's the case, then we protect it right away. But what I tell them is that this protection isn't going to make you money. It's a sheet of paper. What it does is when you go out there and market this name, market this brand, and you start building that brand recognition, we can then go in and slam the door on someone else who's trying to steal your market recognition. Because as we all know, business is based on market share, and you want to protect that market share. And I mean, if it's protecting it right away, fine. But once again, you have to make sure that your focus is on marketing, not just gathering patents and trademarks.
Yeah, this question is for Jack and maybe a little bit for Marlo.
if somebody, what would you say to somebody who, well, I used your photo or your day, but I gave you credit. I said it's from Glauser Images, or this is part of National Day Calendar. How does that work in your spaces without permission, but they gave you, credit for using it?
For us, I wouldn't say it happens really that often without permission. I think people generally have an awareness of using photography and not using photography. And when they ask to use a photograph, we do take it on a case-by-case basis, whether we're going to allow them to use it with credit or whether we're going to charge them for it. So it really is a case-by-case basis. And for us, in an emerging market for us like Colorado, that's a place where we're more willing to trade out that credit and recognition than maybe in Bismarck, where we've been for 14 years. So yeah, definitely case by case.
So you can't go to Google Photos, take a photo, and say that that you give credit in the byline to somebody. That is actually something that you cannot do. I actually learned that the hard way. I thought that by just giving somebody credit, you were actually doing the right thing, and that isn't the case. We're again more of an open source. It would be really, really difficult for us to actually protect our images. I'm not sure how we would ever do that because they're shared everywhere. I mean, we have images that are probably shared millions of times a day. Cheeseball Day, for example, who knows how many times that'll be shared today. But that's the whole point of what we do. We want people to share that image. So it's a little different scenario for us. But if you're actually borrowing somebody's image, you need to call Jack or email him or whatever first, and then get that permission before you give them credit in the byline. You just can't use it without talking to them first.
And we don't require a client to provide us credit. Our clients all have a release to copyright, so they're able to print it, post it, use it within certain limitations. They can't edit it, they can't sell it. And certain clients provide credit and certain clients don't. We obviously like it when they do. So
I think we're going to get corrected now. I knew I was going to hate this attorney thing up here.
Here's what I want to add to that. There runs a concern if you own the copyright or you own the trademark and you do not take steps to protect it, it can become generic. And if a mark becomes generic, it's no longer entitled to protection. So Getty Images, for example, has been extremely aggressive in going out and finding people who are using their photographs without a license. Some of us look at it as, wow, they're just, trying to make a little bit of money. Well, in reality, every image that's taken, whether it's by National Day, whether it's by Glauser Images, belongs to the creator of that image. And the more that image goes out and gets shared over the internet and nobody protects it, the less protection that image has, because it essentially becomes part of the public domain. So as an intellectual property owner, you want to make sure that you take steps to protect your intellectual property, because if you don't, it may be gone.
So if I can follow up with that. So you're absolutely right. In fact, one of the challenges we had with National Day Calendar was they came back and rejected us a few times with the USPTO simply because they thought we were too generic. It's just everybody has it, right? So we had a huge time trying to convince them. And in fact, we're only on the supplemental registry right now because of that. We still have to continue to prove with National Day Calendar that we are actually a full-fledged brand and not something generic. And it goes right back to what you just said. So it's a great response.
Example I always think of is Kleenex, right? It's a facial tissue, but we all call them Kleenex. And so from the manufacturer standpoint, it's becoming generic, which is kind of a bad thing. It's probably kind of neat in a way for them too, but that's bad. If pretty soon the whole world calls those things Kleenexes, they could actually lose their protection.
And it's the same thing you use to clean your ears. What do we all call it? Right. And that's becoming a generic name because it's so hard to protect, because that's the term everyone uses to describe it.
See what you started, Kate? That was an awesome question. Okay, Scott, do I see you holding the microphone?
Yes, you do. So my
my question is, I suppose, for the whole panel, and it piggybacks off that topic. I've seen scenarios where people use an image for a website and it's very generic, similar to something else used elsewhere, and they'll get a letter saying, you owe us $500, and it seems pretty scammy. How do you tell the difference between people who are just trying to scam and make a few $100 or someone who's got a legitimate claim to the image? Is it by dollar figures? Is it, do you ask for a letter from an actual attorney, or can that be forged as well? What do you look out for in that case? Because I know I've seen it happen.
Well, I mean, there's a couple things. One, how much are they asking you for use of that image? So what we're talking about is, do you have a license? Does someone have a license to use that image? And if they're asking for $50,000, there's no license that I can imagine for a photo that you put on your webpage that would cost $50,000. So first of all, we look at the price. And the other question is, you want them to prove that they actually own the image. So you want them to show a license, and most of these, I mean, Getty Images is the big one right now that's really been out looking for people who using their image. The other one is with respect to music, ASCAP. I mean, they're out there trying to find people who are using their songs in a public setting, and they want you to have to pay a license fee. Ultimately, I mean, typically when a client comes to me with these, what I'll do is I'll start pushing the other side. I'll push back, simply because I want to see how serious they are. And if they just kind of drop me, I mean, that tells the story. If they continue on and ultimately I get a letter from a lawyer, I'll typically call that lawyer and ask them questions that relate directly to the license that they supposedly, or their client supposedly has, trying to get to the bottom of, do they own this image? Because what I don't want my client to do is to pay a $500 license fee tomorrow and then get another letter from a different company the next day that says you owe us $500. So unfortunately, we live in a society where there's a lot of scammers, and so we just got to be a little careful and push back and see if it's real.
Thank you. And I think, Dave, you have
I,
a microphone.
Maybe a question for everybody to answer. When does it become not worth your time and money to challenge a trademark, challenge a patent, like Evan said? It's almost like giving up. And too many times, I think that's maybe what your competition wants you to do, right? So when do you make that decision? It's not worth it.
I think it's really purely a financial decision. If you've got the revenue, if you've got the market share that John talks about, if what you're protecting truly has that much value, then it's going to be worth it to put that money into defending, and hopefully you can recover that in whatever suit happens. But barring that, the risk is just too great. I mean, you have no guarantees that you're going to win, and if you're going against like the company that I was talking about, their pockets go clear down to their knees. They've got attorneys on staff that are just looking for things to do that don't really cost that company anything incrementally more to be trying to take my property. So I think that's how I look at it, I guess, is that, and in most cases, in the clients I've worked with and in my own cases, I don't know that I've ever dealt with property that would have been worth that kind of risk. Marlo, you're probably a notable exception just because of the trending on your topic and the value of that brand. But most cases, it's not worth it, and it is kind of like giving up. But at the same time, you still have your markets, you still have the product. I mean, they're not stealing everything from you. So you can fight back in that way too. Now we live in the age of social media, so you can maybe call these companies out on that kind of thing a little bit too, and show the world what they've just done. And that's kind of, in my mind, maybe levels the playing field a little bit. You don't care how many lawyers they have. You just made them look really bad in front of millions of people. So
I've taken a little different approach. I generally try to work with these companies that have, basically, taken our content. So I'll work some type of royalty arrangement out, and that's been pretty successful to this point. I'm thinking of the Instagram. We haven't reached out to them yet, but our plan is to come up with some type of strategy that we can work with them instead of against them. They already have the following, right? So if there's a way that you can work with them and develop some type of licensing royalty arrangement, then sometimes that can work. Yep.
We actually talked to our attorney when this infringement happened, and did send the letter, and did mention royalty and say,
Yep.
gosh, we'd love to work with you. You've got market penetration in places that we don't. This is wonderful. And we got a very curt letter from an attorney's office in New York City, that made it pretty clear that we weren't going to be holding hands and singing songs together anytime soon, sadly. But
And I will tell you, it's different between trademarks and patents. A lot of times the patent companies, or the companies that will steal a patent, are typically very large entities. Rarely will you find another startup business or small business that steals a patent. I mean, they see that there's a patent on there. Typically, they're willing to respect it. Where a large company looks at this and says, hey, that's a great idea, really like it. This is a mom and pop shop. They're never going to come after us. Let's do it. The only patent litigation that I've ever been a part of involved some skid steer parts. And if I recall correctly, just the one side's attorney's fees were close to $500,000 in that case. So that's a lot of sales to make up that kind of money. So you have to look at that and say, okay, do I take that $500,000 and apply it to a patent lawsuit that I may win or lose? Or do I take that $500,000, if I have it in my pocket, and apply it to marketing and just outshine these guys and do social media? And 9 times out of 10, I'll recommend to my clients, you know what, go the marketing route. You'll never lose that way.
They're going to call us the doom and gloom panel here. So,
Yeah, you all getting real
One
depressed
more,
over
I
there?
had one more question. John, this one's related to you. How you doing, John?
Good, how are you, Dave?
Trade secrets. That wasn't mentioned today, and I think that's an important, because a lot of people are going that direction. Can you maybe explain a little bit the difference in how trade secrets might be an option for people to go?
I will tell you, if there's even the slightest possibility that your idea, invention, whatever, can be maintained as a trade secret, absolutely, that's the way we grow. We go. Because at the end of the day, there's no time limit to a trade secret. It's a whole lot cheaper, and it's absolute protection. I mean, for example, Coca-Cola's recipe for Coca-Cola Classic, or whatever they call it nowadays, it's not a patent, it's not a copyright. It is a trade secret. And they have maintained that secret for 100 years. So ultimately, that's the way you want to go. And here's what's required for a trade secret, is that if somebody gets it, puts it in their hand, can they recreate it? So if you have a pair of eyeglasses and they can put them in their hand, they can figure out how to make those. If you have a photograph, can they figure out how to make that? But if you have something that, and a lot of times recipes for secret sauce are trade secrets, because you really can't figure out just by looking at it, even tasting it, exactly what goes into that recipe. And I'll tell you, every day, trade secrets are where it's at for me, because I mean that is the strongest protection you can get. And what goes in with those are non-disclosure agreements, so that anyone that would happen to come upon that trade secret or have access to that trade secret, you have them sign a non-disclosure agreement, and then your burden is to make sure that you enforce those non-disclosure agreements. And we've heard a lot about non-disclosure agreements with our current president, and It's a little different than that, but similar.
Great question. Okay, we've got one in the middle there.
Hi, I just recently moved here from California. I'm a patent attorney. I have a question for Evan. So it sounds like you do a lot of provisional filings for as part of sort of a licensing strategy. What goes into your decisions of which cases you convert into non-provisionals and which you just sort of let go away?
In a lot of cases, the end goal is a licensing agreement, because the client doesn't have all of the resources necessary to actually take that product all the way and get it to a market. So it's bluff is maybe not the right word, but it's a way to be able to say this is patent pending as soon as you file that, as you know. And then if during that year, if you get some traction and things are looking really good, then it gives you a little more confidence. If you've had some focus groups, things like that, it gives you a year you're protected, but you can really make sure you want to spend, that 5, 6, 8, 10, 15,000, whatever it ends up being to get the patent. So the provisionals are a pretty easy decision to make. I mean, they can be filed. People can file themselves on LegalZoom. It's not great, obviously, but it's something. It gives you that air of protection, just being able to say, hey, I'm patent pending. So are you practicing here?
Yeah, actually, I still work for the same firm in California, in San Jose.
Based here?
Yeah, I'm based here.
Come and see me after.
Okay.
Oh, we have a question. Oh, we have a couple of questions. All right. We have an adamant question.
Just a quick question. Do any of you know of any organizations that operate similarly to like the ACLU, who will step in and defend people in like creators and inventors in your position? Maybe one should be created.
Would you like to start one?
Yes, I think we should. And that's why I'm asking. Just,
I know there are certain funds available, I think, to help people maybe protect their ideas and things like that. Free legal help and those kinds of things for depending on people's ability to pay and that. But I've never heard of anything on the defense side of you, John.
So this is sort of an opinion question, and it probably applies most to Marlo, Evan, and John. Have you ever encountered patent trolls? And do you have an opinion? And have you ever had to deal with one? A patent troll.
That's
Short.
what they look like, by the way, too. They're
Yeah.
short gargoyle like,
So-
and yeah, that's
So
how
I guess anybody that's
anyway.
not familiar with the term,
I've had to
somebody
deal
who
with
holds
this, so.
patents for the sole purpose of weaponizing them and going after people that have a product and somehow through their interpretation infringes upon that patent. Typically it's software. You'll hear software patent trolls, but hardware has also happened. Third parties get involved sometimes too, simply because you use a technology, somebody might come after you. Have you ever had to deal with one? And I guess, John, from a legal perspective, how do you fight something like that?
Never dealt with one, but I suspect that there's a lot of dollars involved. I mean, I can't imagine someone with that much spare time and that much spare money to be in, basically fighting over intellectual property, trying to wrestle it away from somebody. But I could see it in a big arena, where you've got the Apples of the world and those kinds of things, where that IP is so valuable. John, is that?
Where I've actually seen it is someone will license software, a business, for example, will license software. That license will expire. They will not renew it. And there are firms out there who I am not a techie, can figure out who's still using that software based on their web searches, and realize they don't have a license for it and will go after them. And there's a fair amount of that. I mean, I had a client in Las Vegas who ran into that not long ago, where they had an expired license And boy, it wasn't soon thereafter as they were getting letters from lawyers saying you're infringing. So, I mean, there's a fair amount of that. Frankly, my client was in the wrong. They should have renewed their license if they were going to keep using the software. But there are companies out there that are watching it very closely. And part of that goes back to what I said earlier, is that, you know, as an intellectual property holder, you have an obligation to protect your intellectual property. And, you know, that's really what, you know, they may not do it in a very kind way, but that's still what they're doing.
So a lot of it is it's kind of about a shakedown, in my opinion. So when we were, as soon as we registered, or as soon as we, you know, put into the USPTO about our trademarks to Celebrate Every Day and National Day calendar, we were flooded on the Celebrate Every Day side with people who claimed that they had rights to this, and we listened to them all, but most of them were basically doing exactly what you wanted, that you're saying. If you want to move forward, you know, we're going to hold this up as long as we can. And there's a game there. There's like, you know, USPTO will send you a letter. You have 90 days to respond. You know, a lot of times if you're trying to hurry this up, you'll respond in 2 days, but the people who are challenging you will wait till the 90th day. And then this whole cycle starts over again, right? So they can tie you up for years doing this. And what they're hopeful for is you're going to say, fine, here's $50,000, go away. I mean, that's what they're after. And I'm assuming that's kind of what you're kind of getting to. I usually tell them where to go. So I've gotten a little stronger in my stance over the years, kind of like what John was saying. I mean, you need to maybe investigate a little bit, but you just like the Getty Images thing, you know, you really just need to address them really quickly and find out how serious they are about it. And sometimes, you know, I remember the one instance, the person who was really tying us up ended up having 36 shirts that had Celebrate Every Day on them. And they tied us up for a year. And it was, and I don't take this the wrong way when I say this, but it was their attorney talking to our attorney, and it cost me like $80,000 in attorney's fees over this, right? We settled for $1,000. If we could have just had the conversation with the person to start with, it would have been done and over with. So sometimes just reaching out and visiting with them gets you a better understanding about where they're at. So.
Yes.
Yeah. Hi. Where does, say, working files you've developed within a software or a library of assets that you've developed on your own time fit into this landscape of intellectual property? How careful should I be about sharing files with other people? Say a spreadsheet I've worked really hard on that's really useful for me. I don't want someone else to be able to take it and use it in that same way without having put that time in. How careful should I be about sharing files with other people? And basically.
Well, you raised a couple questions. One, who owns that? In other words, did you create it on your work time, and is what the copyright refers to as a work made for hire? So if it's a work made for hire, your employer owns that, and essentially they have the right to use it for whatever they want to use it for. If, on the other hand, it's your own creation, it's not owned by your employer, technically it's protected automatically under the copyright as an original work of yours. You know, that there's some back and forth, and you'd probably be able to speak to it better, of how much the patent office will protect or is willing to protect software. There was a time where they weren't willing to protect much of any software. But your main protection at this point would be copyright. What I hear from you is, I use it, but I don't really want to disclose how I came up with it or what the source code is behind it. And if that's the case, assuming your employer doesn't own it again, you have no obligation to disclose that source code. And it's that source code that you own and is your intellectual property. So, I mean, you can file it with the Copyright Office, or, for example, if it can't be reverse engineered, it's a trade secret. Does that answer your question? Okay.
I'm stuck on copyright again. For example, and commercial versus non-commercial use. For example, a politician I can't stand was hired by Notre Dame yesterday, and so I posted a snarky response to that on Facebook, and I used a picture that I found on the internet of this politician. Am I liable? Number one. And number two, on the same idea, you see politicians all the time using music from bands and groups that can't stand them, who oppose them. What's the legal issue?
Well, what you'll find with some of these politicians who use music of bands that they can't stand is sometimes those bands don't own their own music. They don't have the license to that music. So the politician may have licensed it properly. And so what you'll hear is the band come out and say, you know, we never wanted him to use that music. Well, frankly, they may not have any say in who can use that music. As far as images, and this goes back to Jack, every image that one of his photographers takes is automatically a copyrighted image owned by Glosser Images, because his employees and his subcontractors all do the work made for hire. So all the ownership goes back to Glosser Images. So if you use one of their images, my recommendation, and they become aware of it, my recommendation to Jack would be to tell you, take down that image, we own that image, we didn't give you permission to use that image. Whether it's, you know, on your personal website, on a company website. Because at the end of the day, my goal is to make sure Jack's protecting his intellectual property. And by using that image without his license, and he may come back and say, either take down that image or sign this license agreement. Either way, as long as he has some control over the use of that image, he's still protecting it.
Well, thank you for the great questions. Oh, I'm sorry, Jack, yes.
If I can add, for us, it's really a matter of educating our clients, you know, so that they are aware that they cannot use the image, you know, and also I think you have to also like kind of police the internet in a sense to find those images. It would be very hard unless someone told us or it was a localized thing for us to kind of find out that an image has been used. So those two things I think are important too.
Okay, great questions, everybody. I think they feel properly grilled. Do you feel grilled? All right. Tyler, would you be willing to ask our last question?
Absolutely. So we're a little different this morning. Usually we ask, how can we support you guys? But because so much good information here today, thank you so much for being here. We're gonna switch it up a little bit. For anybody who wants to dig deeper into this or gain a little different perspective on it, can you bring up one resource, whether it's a podcast, a book, a case study, a story, a blogger, one resource just real quickly that you would recommend digging into a little more?
I would go to USPTO. They have I think is it TEAS search or whatever it is, right? If you're looking to trademark something, just like John was saying, if you're looking to start a business or whatever, you don't want to infringe on what somebody else has had, right? You can actually go in there and do a basic search for free. At least it gets you started about, you know, when you're dreaming about a name or whatever, to know that maybe that name is taken or not. So
I would say John. John's also my attorney, and you know, we have it pretty easy when it comes to copyright because it's an automatic thing. But when there are issues that do come up, which frankly do rarely happen for us, John's the one who gets the questions. So.
And I would echo uspto.gov. That's the real information. Yeah, you can go to YouTube like you do for everything else, but there's a lot of weird stuff out there that most of it not true relative to this. If you want to put a new hard drive in your laptop, great. But patent advice I haven't found to be real good. But uspto.gov, they actually have some good videos, a lot of good stuff that's downloadable. I spend an inordinate amount of time there.
You know, I think your best source are people like these who have been down the road before. And I mean, they'll all tell you there's ups and downs, and it's the school of hard knocks a lot of times. And you know, you get a trademark in your hand and you figure you got the world, and then you quickly realize that someone's using your mark and this person's using your mark. And so it's a forever evolving thing. The Patent and Trademark Office is a great website. It's very helpful. It can describe some of the process. You don't need to go hire a lawyer to search a trademark. Most lawyers who are worth their salt, if you come to them and want to trademark something, they will do a search on their own, because no lawyer wants to later explain, hey, you just spent, you know, $1,500 for this trademark, but I guess it's already trademarked. So, you know, there's some valuable resources there, but at the end of the day, talking to people who've been down the road is absolutely your best source.
Awesome, thank you. Can we give it up for our panelists? Woo! Hey, as long as we're clapping, could we also clap for our tech crew up there in the booth? They are absolutely amazing. They're fantastic. Well, thank you all for being here. Catch these guys after if you'd like. Evan, I know you got eyes right there. And next week, get it on your calendar, because next week we have Robert Thornburg. He's with Food First. He's got probiotin bars. He is bringing samples, and he is manufacturing up in Walhalla, North Dakota, my hometown. So please come and support Robert. And if this looked good and you had a lot of fun and you'd like to be up on stage, it's really not that bad, trust me, then please apply to present. I know Kate has shown us that before. You go out to our website, and there's a link, and it's a very easy form to fill out. There's just a couple of questions, maybe 3 paragraphs tops, that we're going to ask you for the information, but we'd love to see you on stage. Or if not on stage, we'd love to see you in the seat you're in right now next week. All right, thank you.